Just skip it.
Harry Frankson was 13 years old when he began to smoke in 1954. Within a year, he was smoking a pack of cigarettes a day. In the 1990s, he made a number of attempts to quit smoking, but could not do so. He was diagnosed with lung cancer in September of 1998 and died of lung cancer caused by cigarette smoking in February of 1999. Trial of this action commenced on November 17, 2003. On December 18, 2003, the jury returned a verdict awarding a total of $350,000 for compensatory damages, of which $100,000 was awarded for conscious pain and suffering. On January 9, 2004, the jury assessed a verdict of $20 million in punitive damages against the defendants. The jury apportioned 50% of the responsibility to the plaintiff's decedent. Over the past 6 years, this court has presided over approximately 50 individual smoker cases, 3 of which have gone to verdict. The first 2 verdicts were defendants' verdicts. In the course of this period, this court conducted extensive discovery proceedings, made hundreds of rulings, supervised jury selection, and looked at hundreds, if not thousands, of pages of documents, and as a result became very familiar with the essentially closed universe of tobacco litigation. Many of the issues that were raised in the instant suit were previously litigated and decided. Here, as previously, much of the work of the court involved the structuring of a streamlined litigation procedure that would afford both sides a fair opportunity to present their cases while appropriately limiting the voluminous amount of information that threatened to inundate rather than illuminate the jury. Thus, this court granted guidelines for document discovery, rules for taking fact witness depositions, modes for limiting expert testimony, and methods for determining the admission or preclusion of evidence. Many of the court's rulings upon these and related issues in the instant case were restatements of the earlier pretrial and trial rulings, which reached usually after lengthy argument and briefing by both sides and much considered deliberation. Accordingly, this court is annexing and incorporating herein some of its earlier decisions upon which it relied in granting or guiding the course of this trial. On July 25, 2000, deciding the question of whether a cause of action lies for the willful failure to warn, March 28, 2001, deciding whether business documents retrieved from the web are admissible. June 20th, 2003, short form order deciding defendant's motion to compel certain authorizations. June 23rd, 2003, short form order fashioning a mechanism for the examination of certain cytology slides. September 23rd, 2003, decision after an in-camera review of decedent's military records. December 1st, 2003, decision on various evidentiary issues. Also incorporated by reference are 2 contemporaneous separately published decisions of June 22nd, 2004, dealing with the following additional issues raised in defendant's motion for a new trial. A, whether the defendants were entitled to waive the affirmative defense of comparative negligence. B, whether this court properly precluded evidence of unsubstantiated scientific opinion. The defendant argues that they were not given the opportunity to depose certain unspecified fact witnesses, an argument that appears to be belied by correspondence copied to this court, which indicated that any remaining difficulties in this regard were resolved. Be that as it may, this court was mindful of the fact that a lawsuit can have a ripple effect and impose intrusive and burdensome obligations upon individuals who may have only the vaguest and most remote connections to the case. Accordingly, the court streamlined the number of non-party depositions to be taken from individuals whose testimony could at best have been described as cumulative by imposing a decade rule which provided for the deposition of one fact witness for each decade the smoker smoked, in addition to the deposition testimony of the parties.
Double.
I went